Good afternoon. I'm Susan Hoskins. We've been doing this monthly series on aging, and today we're talking about legal and estate planning. And I'm delighted to introduce my friend Lisa Collins from Fallsington Meeting, who has a practice in Yardley and is a great resource on this topic. So, Lisa.
All right, thank you. Hi, I'm Lisa Collins. We have this, it's the PowerPoint thing that Scott has put together using my outline, just largely for your reference, because I tend to wander sometimes when I'm talking, go off on little sidebars, so that you know what I'm supposed to be talking about. It's up there. And also, I will try to refer to it and stay on track also. But essentially, as Susan said, I'm an attorney, and my practice is focused on wills, estates, probate, and we'll talk about a little bit what that means. So, and my contribution, of course, is to talk about the legal things that we should think about as we age, and really, since we're all aging, it's really never too soon to think about doing this. So I'm going to talk about 3 documents that I always suggest that people have when they come to me for estate planning. And those are a will, a durable power of attorney, and healthcare. What do we call it? And here's the kicker. It's like it has like 16 different names. I think I only put 2 names up, but there's a healthcare power of attorney, living will. It's lots of different names that this particular document that deals with our healthcare is known by. So we'll talk about that. So we'll start with talking about will. So there's 2 ways to die. I bet you didn't know that, right? You can die with a will or without a will. So when we talk about with a will, it means you die testate. If you die without a will, it's intestate. So what difference does it make? On one level, it makes no difference at all because A, you're still dead, and 2, we still have to do things with your property, whether you have a will or not. But so the will is the document that disposes of your estate. And so, well, what is your estate? Your estate is everything that you die with. I'm saying this backwards. Or it's all the assets that are in your name when you die. Cash and securities or intangible property, personal property is your stuff, real estate, all those kinds of things can be titled in your name. So what's intangible property? And intangible property, as I said, is things that you cannot put your hand on. So money, securities, intellectual property is a good example also. Okay. And so a will distributes that, and it names an executor. So those are the 2 purposes of a will. And those, as I said, also has to happen even if you don't have a will. So if you die intestate without a will, that means that you haven't named anyone to be in charge, and you haven't set forth a scheme for distributing your stuff. So, and so then what happens if you're intestate? Well, every state has what are called laws of intestacy, appropriately enough. And so the state sets forth a scheme for distributing your estate. And it just, it looks at family members, your close familial members, and then it just branches out, and there's a whole scheme in order. So that, which may be exactly what you want to happen in your will. So it may be that if you die without a will, the same thing happens as if you died with a will. You know, it goes to your spouse, not your spouse, and to your children or whatever. So it may be of no consequence that you die without a will, but on the other hand, it could be a huge consequence because really what happens isn't necessarily what you want to have happen. So the importance of having a will is that you've decided where your stuff's going to go and who's going to be in charge to make sure that that happens. So property can be owned in different ways. Anybody, if you own a house, you probably already know if you're married, you can own it jointly with your spouse. And in Pennsylvania, there's a special kind of joint ownership called tenancy by the entireties or tenancy by entirety. What does that mean? It's just really a special kind of joint tenancy that's created specifically for spouses. And it offers certain protections that other joint tenancies don't necessarily offer. And most states do not have tenancy by the entireties, but Pennsylvania does. So that's one way to own property, is jointly, in which all parties own an undivided interest of the whole. Or you can own as tenants in common, where each party owns their own divisible share. In other words, you can give it away, you can leave it through inheritance, that sort of thing. So how property is titled, how it's owned, can also determine whether or not something passes through your will. So if you have a joint tenancy with right of survivorship or tenancy by the entireties, that passes outside of your will. In other words, that title relationship determines how it's going to descend or pass. We say that it passes by operation of law. So the will does not control that. But of course, if you own something as tenants in common, then the will does control that because you have a share of that property that you can give away. So that's important. These are sort of the elements that go into when you make up a will. You know, you think about, well, what property do you have? How is it owned? How is it titled? And then of course, you know, who do you want it to go to? So if something passes outside the will, we put that in the category of non-probate. If something passes through the will, it's probate. The will only really governs probate property. So it's everything that's titled in your name that doesn't otherwise have a beneficiary designation. So some of you may have non-probate property. In fact, increasingly, more and more of your estate is non-probate, like 401ks, retirement accounts, investment accounts where you've named a beneficiary, or just even savings and checking accounts where you've named a beneficiary. That actually passes outside your will, so that operates by contract. So you said, this is who the beneficiary of this instrument or this investment account, that's where this is the beneficiary and that's where it's going to go. So does that mean that it's not part of the estate? Well, in a global sense, it's part of your estate because you owned it. But in terms of whether or not it's controlled by the will and part of your probate estate, you know, versus your non-probate, it's still part of your estate. Now, then, of course, then you get into the question of inheritance tax, which is a whole another thing. Just in terms of how it passes at the time of death, if there's no beneficiary designation on the property itself, then it passes through the will. The will controls where it's going to go. But if it's a contract, which like, you know, an IRA where you have a beneficiary designation, life insurance, you know, usually you have a beneficiary designation. If you have something like life insurance, though, where you don't have a beneficiary designation, that goes to your estate. And so then what would ordinarily be a non-probate asset then becomes a probate asset. So it's a little complicated, but just generally, you know, probate property, non-probate property, you want to think in terms of, does something have a beneficiary designation or does it not? So the question is, what's taxable? And that's often a concern of people when they come to me. It's like, well, you know, inheritance tax. And in Pennsylvania, we don't have an estate tax. We have, so we're really just concerned about inheritance tax. And inheritance tax is a transfer tax on property that's passed, you know, from a decedent to a beneficiary, whether it's probate or non-probate property. So just because something is non-probate property doesn't mean that it's not taxed for inheritance tax in Pennsylvania. And remember, there's 50 different states with 50 different sets of laws about this. So we're just talking about Pennsylvania. I'm also licensed in New Jersey. I can talk about New Jersey too, but we're going to stay in Pennsylvania because we only have how much time. So anyway, but it's similar. So probate, which we're slowly working my way towards what happens at the time of death, is what we call probate. And so what you're talking about, the question was raised, what happens to out-of-state property? Particularly if it's real estate, states get to say how, what rules control or govern the transfer of real estate, because you can't take that property out of the state. That's part of the, literally part of the state. So we have a process that's called ancillary probate, and those rules, and you follow the rules of the state in which the real estate is located. So probate, and then you might have an ancillary probate if you have property owned in another state. It gets a little complicated, but so probate. So the question is there some threshold below which there's no tax on inheritance in Pennsylvania? And the short answer to that is no. It's all taxable, but the tax is on the net estate, so you get to deduct the expenses and the debts of the decedent, the expenses of administration and the debts of the decedent. So any debts that were owed by the decedent at the time of death, plus administration expenses, which include things like funeral and whatever else. So you pay on the net estate, and the tax rate is determined by the relationship of the beneficiary to the decedent. So between spouses, the rate is 0%. From parent to child, or child to parent, lineal descendants, so think in line, parent, child, grandparents, parents, the rate is 4.5% on the net. And then you have collateral, like sisters, siblings, 12%, and then collateral, and then 15% for anything that doesn't fall into those categories. So that's the Cliff Notes version of the Pennsylvania inheritance tax. Without a will, what I like to say to clients is, if you don't have a will, the state will make one for you. There are intestacy laws which determine how property descends, and it's just set in black and white. If you're married, it's going to your spouse. If it's your second spouse and you have children from your first marriage, then half is going to go to those children and half is going to go to that second spouse, which may or may not be what you want to have happen, and then et cetera, et cetera, et cetera. So there's a whole scheme. So people do worry about, well, if I don't have a will, it's going to go to the state. Well, yes, that will happen if after, there's really nobody left in your family tree for it to go to, then it will escheat to the state. But I have yet to see that happen. So right, the inheritance tax is the same, whether it's through will or through intestacy. Again, the tax is determined by the relationship of the beneficiary to the decedent, and that's whether there's a will or not a will. So, and so then you get into the whole arena of planning. Some people feel very strongly about avoiding inheritance tax. And I said, well, the only way to avoid inheritance tax is to die not owning anything. There's that. You can do that. That's fine. You can give it all to your children before you die. Yeah, that's also another conversation. At the time of probate, what happens is really the process for if there's a will or not a will is very similar in many, many ways. There's an administrator or an executor that gets appointed. If you have a will, it's called an executor, and that person or persons or institution or bank, whatever, has been named in your will. In the case of an intestacy, the person or whomever is called an administrator. But the process of administering the estate is the same. The role of the executor or the administrator is to gather up all the assets, value them, determine what debts there are, pay the debts, pay the expenses of administration, the funeral and everything, and then at the end, and then pay the tax. And the inheritance tax is due 9 months within the date of death in Pennsylvania. We're only talking about Pennsylvania. And then after that, then you make distribution. So the roles and the job of administrator, executor is the same. So the process of probate is the same, really, whether there's a will or an intestacy. I mean, there are some differences, but this is not law school. I've already had a few people leave. No, I'm just kidding. It's all fine. So in Pennsylvania, you can have what's called a holographic will, which means you can write it out. Some people like to, I don't know, hang glide without, I don't know, parachutes or something, or I don't know, but it's a risky business is what I'm trying to say. The actual requirements are somewhat minimal. It does need to be signed at the end thereof and dated, and needs to show a testamentary intent. In other words, that you intend to give away your estate, et cetera, et cetera. And it does all the things that a will should do. So in theory, yes, there's law school classes are filled with cases that, wills written on the back of a napkin, or, all these kinds of crazy things. But, yeah, the requirements are pretty minimal, but many is a slip between the cup and the lip. Yeah, I mean, I have seen wills that people have drafted on their own, just trying to save a few bucks. So they went and maybe they got a form at the stationery store, back when there were stationery stores, remember them? And or maybe they found a form online and they said, oh yeah, any idiot can do this, because lawyers are idiots, right? And so they just go fill it out, yeah, and then and 9 times out of 10 they've messed up the execution, which you think that'd be the easy part, signing it and having witnesses and all that kind of thing. But I know this is a very circuitous way to answer your question of whether a will needs to be witnessed. The short answer was no, but so witnesses are important to show that the testator did actually write this will, that they were competent, they were at least 18 at the time they wrote it, and that's basically what you have to have. So lawyers, what we do is we generally have 2 witnesses and a notary. So usually when I'm doing a will signing, sometimes that's the hardest part. It's getting enough people who can show up for that event. It is sometimes a little bit of an event. You have to have 2 witnesses who are not named in the will, or not parties to the will, and a notary. The question really is, you write a will, or any other, well, I presume you're talking about a will because you're not there, right? Or if you're incompetent, maybe you're talking about a probate. Anyway, you're talking about a will and you're gone, and someone wants to challenge your scheme, your testamentary scheme, what you have in the will, what you want to have happen. Can they do that? Well, sure, people can try to do that. And so what are the bases on which they would be successful or might be successful? There's different bases on which to challenge a will: fraud, duress, the typical contract basis, or undue influence is a big one. So if someone could show that someone got you to change your will because they would benefit from it or something, yes, they might be successful in doing that. But I will tell you, it is very difficult to challenge a will, assuming that all of the requirements of execution are met, assuming that it's validly executed in terms of where it's signed and all that, and dated, et cetera, and also that the person, the testator, had testamentary capacity, which is a fairly low bar, meaning that You know, they knew who they were, who the natural objects of their bounty were, meaning who would they naturally give their estate to, and also what their estate was comprised of. So that's basically the threshold test for testamentary capacity. So they can challenge testamentary capacity, for example, that, you know, this person didn't know what they were doing, then that's a basis on which they could perhaps upset a will. But in practice, it's pretty hard and expensive too. But probate, one of the things you need for probate is the original will, not a copy. There are circumstances in which you can probate a copy of the will, but it's hard and it requires going to court. So you need the original will. And what happens when you go to probate the will, you take it to the Register of Wills with your check and your death certificate and your identification if you're the executor to get yourself appointed, and they inspect the will to make sure that it wasn't tampered with, that there were no interlineations. In other words, there was no little scribble-scrabbles here and there or crossings out or anything like that. And they're going to look and make sure that it wasn't unstapled. So they're going to inspect the staples to make sure they weren't removed. You know, sometimes people say, oh, I'm going to make a copy. You know, the easiest way to make a copy is just to take it apart and put it through the automated document feeder. No, please don't do that. So what I do, actually, I give people a copy of their will to take with their original. So I say, this is a copy that you can play with, okay? But you shouldn't write on it. You shouldn't write on the, do not write on the original will or do it. I usually fold it up in a nice pretty envelope and say, here, put this in a safe place. Here's your copy to play with. But yet, don't do that.
But you can add codicils.
Yeah. But yes, can you change a will? Absolutely. We stopped the practice of writing them in stone many centuries ago, and we do them on paper. They are very changeable. All you have to do is just write another one, and it revokes. We have a clause in there that says this revokes my previous will. So yes. So we'll move on to powers of attorney. Now that you know what happens when you die, I've answered that question for you, right? Good. Okay. So what happens while you're still alive and you need someone to step in and handle your affairs, pay your bills, whatever, whether you have some sort of temporary or permanent incapacity? Well, we have what are called powers of attorney. I'm sure most of you have heard of them. Powers of attorney are what were created as an alternative to guardianship. Guardianship is a court-overseen process. So if someone cannot manage their affairs, you know, you would have to have someone do that for them. So you could go to court and say, court, I'm a responsible person. I can handle this person's affairs, you know, their finances and whatever. Please appoint me. And that, as you can imagine, going to court is a complicated and potentially expensive process. So instead of doing that, and it might not be the person that you would otherwise choose as the dependent person. So what we have are powers of attorney. So you, we call you the principal, can create one of these. And what you do is you're naming a person or persons to handle your affairs and do almost anything and everything as if they were you. So that if you get into an accident or you're incapacitated in some way, your bills will get paid and the things that you need to have happen can happen. And that all powers of attorney in Pennsylvania are durable. So you might have heard the phrase durable power of attorney. Well, we usually don't even say that. We just say power of attorney because by statute, all powers of attorney are durable unless they're specifically limited. So, and they can be very broad or they can be limited. Usually in the context of estate planning, when I'm drafting powers of attorney for people, they're broad. I mean, they really, and so that's a huge responsibility and it's a huge power to give to another person or person. So we treat them with great care. And two different ways that I usually do them. They can be effective immediately. So from the moment that you sign it, that person would have the right or the power to go and do all those things as if they were you. That's scary, right? So, of course, the lesson of that is that you wouldn't give someone that power unless you absolutely trusted them with that power. So, you balance that out. The other way of writing it is doing what's called a springing power of attorney, so that it only takes effect upon your incapacity. So, and what I do is I put language in there that says that your incapacity basically has to be certified by 2 physicians, saying that yes, this person is not capable of handling their own affairs, and so that springs the power of attorney into action. So there's 2 ways of doing that. I would say the vast majority of the ones that I do are effective immediately, because people usually, when they reach that point of drawing up a power of attorney, they've got somebody they trust, and they're not concerned that that person's going to run off to the Cayman Islands with all their money, which of course is against the law. If you weren't sure, you're not supposed to do that. Okay, so what are some of the parts of a power of attorney? Well, the principal, that's you. You must sign. There's a notice. In Pennsylvania, is a required notice that's smack dab on the front of the document, and it's in bold, capital letters, and that's actually required by law, that you sign, as the principal signs, saying that you understand what you're doing. So you have to have a testamentary capacity. You have to have the ability to execute this document at the time that you sign it. And you say, yes, I understand that I'm giving another person or persons this huge power, and I do it willingly and all that. So that's kind of what I call speed bump. There's various speed bumps that are put in place to make sure that these documents aren't abused. And the other thing that that is included is the agents, the person that you've given this huge power. They have to sign an acknowledgement saying that they understand that they have this huge power and that they can only act in the interest of the principal. In other words, they're not allowed to go off to the Cayman Islands and spend all your money. They can only act in your behalf, and that they understand that that's the responsibility. And how do we enforce that? Well, anyone can petition the Orphans Court to have that agent removed, or to otherwise investigate. You can also report them to Area Agency on Aging, but they can definitely be held accountable in court. You can't, if you're an agent, you can't commingle the principal's funds with your own. All this stuff may seem very obvious, but bears repeating. And you have to keep track, So at the very least, a checkbook register, that kind of thing. Because if you are hauled into court, you have to account for what you did. What money did you take in? What did you receive from the principal? Where did you spend it? And all that kind of thing. All should be obvious. Okay, so the third document that I always recommend that people have when they're doing their basic estate plan is health care power of attorney / living will. I mean, you will hear this referred to as just a living will or medical directives. I mean, oftentimes you go into a hospital, you go to a doctor, they ask you, do you have a living will? Well, what is that exactly? There's usually 2 parts to that. The living will part is meant to be the expression of your wishes if you have an end stage condition or are in a permanent unconsciousness. And probably many of us are familiar, or at least in some way, of newspaper accounts of famous cases like Terry and Schiavo, Karen Ann Quinlan, Terry Schiavo, and others where there's been battles between family members of what to do with someone who's in a coma. Would they have wanted to have the proverbial plug pulled, or what? What would they have wanted at the end of their life when they're not able to make those decisions themselves? So it's 2 things. It's like you're not able to make those decisions yourself, and also you're at a stage where the statute says end-stage condition or permanent unconsciousness. And there's actually a statute that governs this thing. And there's, right, so you probably tell you there's like 7 different things that it addresses, like, you know, do you want, I mean, even antibiotics, hydration, tube feeding, cardiac resuscitation,
That's
yeah,
enough.
that kind of stuff. So those things are usually listed in the living will as to, you know, and you can check them off, yes this, no that. I mean, a lot of it sometimes it gets down to comfort care, what, you know, and everybody feels differently about different things. Like, well, yeah, maybe you don't want to be on a respirator, but, you know, you do want antibiotics, or maybe you want hydration, or maybe you do want tube feeding, or maybe, you know, maybe you don't want any of that. So there's, and every attorney has their own document, so there's a gazillion of these. I myself have like several. It's because everybody's different. It's what it is. It's an attempt to put a gray area into black and white, and it's virtually impossible, but you do your best. It's what really happens in the real world when you have this document and you present it at the hospital or wherever, and it doesn't exactly go as planned, or they have their own routine because the hospitals, like banks, like to do that. They like to make their own rules about things. So, yeah, again, it's a gray area. I mean, I myself have been the agent under a healthcare directive for a client who didn't have any family members. And even for me, someone who works in this field and is familiar, both are like sort of a little bit on the health end of things as well as the legal end of things. I was there with a doctor, like, oh, I don't know, what would you do? I don't know what you do. Or like, because it was fluid and the situation is changing and there isn't always certainty. I had a client who, she had, you know, like, no, don't do anything extreme. And her personal doctor wanted to put in a feeding tube. And I said, hold on, no, we're not going to do that. And then the specialist, I think he was a gastroenterologist or whatever, we kind of had a little consult because at that point she was, I guess she was in a state of unconsciousness, not necessarily permanent, but she certainly wasn't able to communicate for herself. So we're like, what are we going to do? This person was, you know, may have been 90, I forget, but or close to it, and was very frail, and we really thought for all the world that she was going to die very soon. So why put her through, and plus she had the living will, why put her through, you know, the trauma of having a feeding tube inserted, which is, you know, really it's kind of that's a one-way street for the most part. So we had a little conversation. We said, no, we're not going to do it. And we're just going to wait and see what happens, because there was a chance that she would come out of this. And lo and behold, she did. She woke up and she went back to her assisted living facility and was able to resume her life for a short period of time. I mean, she ultimately did die not too long after that, but it was in a much more peaceful, controlled setting with hospice care, and I think we had a harpist and everything. I mean, it was quite nice. And so it was a very different setting and situation. But it's like we didn't know. We did not have the answers at the time. And so
I think that probably depends on the healthcare facility. If you have the documents with you, you're in better shape than if you just say, yes, there is one. But the point I want to make here is also it's so important once you've created the document to have a conversation with the person you've appointed.
Thank you. Yes.
Because, you know, Lisa knew, let's assume, that you knew the client, you were talking about it.
Right.
You knew what her wishes would be and which direction she might tilt in if she had been capable of making the decision for herself. The check boxes isn't enough.
Yeah, and some of the forms, as I said, I have a few different forms, and I'm always, you know, playing around with this because it is so hard. There's one I started using recently where there's empty lines where you can write in, this is what it means to me to be comfortable, or to, you know, this is what I don't want to have happen. This is where I envision things, and it gives you the space to actually give guidance, because really at the end of the day, that's what it is. It's guidance. Okay, that could be
I can
a
speak to that.
DNR,
It's the post.
the pulse, yeah.
The difference is that the post is a physician's order. It
yeah.
must be obeyed. A living will is a suggestion.
Yeah, and in a living will, you can say, I give my agent, I'm sorry, I give my agent permission to, get my doctor to do a DNR or.
Right. If you want the emergency squad to abide by it, it needs to be in a place where they can find it immediately.
Yeah. Right.
So
Yeah, go
this
ahead.
is one that you can use, which you can fill out yourself and have witnessed.
The most important thing you can do is have a conversation with the people who you expect to do these things, because they're going to best know what to do, because that's really how it works in practice. Is there's people there, and if you don't have one of those, what happens is that the hospital or whoever reaches out to the next of kin, and it's basically whoever they can get a hold of. Usually it's a spouse. I mean, there is, they're going to, if there's a spouse, they're going to go for that first, and family, and then whoever's there.
The 5 wishes is a legal alternative to
And it's basically
the 7
an advanced directive.
versions that Lisa has. They're all legal in Pennsylvania. The post, in addition to being legal, is a medical order,
Right.
because it's signed by your physician or your nurse practitioner. And so that one carries more weight. The thing that you need to be careful of with the post is that it must be abided by. So if Lisa and I go on a bike ride on the towpath and crash, we might then want intervention, the antibiotics, that when we were just thinking, oh, when my dad died at 98, I don't want to go down that road. Mm-hmm. So you may want to have the flexibility that's built in with the living will, the advance directive, because then your proxy, Scott, if I'm unconscious, Scott would have to decide what would she want to do. He's got some more flexibility than the post. For those of you who are living in senior care, and particularly if you have some, I tell people, do the post when you have an idea about what your end is going to be. That it's going to be near, and it's because you have metastatic cancer and you really have decided that you're ready to let go and don't want the invasive treatments. Then a post makes a lot of sense. So hospice uses it often as one of the documents that they bring when you first start on hospice. And you want the decision maker to be the person that's most able to handle that responsibility. Some family members are just paralyzed by it, or what we call the brother from California, who comes sweeping in. The sister's been doing the daily care for 3 years. Suddenly the brother sweeps in from California and says, oh, you can't let him go. So you want your decision maker to be someone who's comfortable with that responsibility, which is why you have them sign off on it.
Well, right. So choosing your agents, that's a really important thing. And that's a question, I mean, that's something you need to think about when you're choosing your agents under the power of attorney, for financial affairs also. And they may not be the same people. They very often, especially if parents are appointing children, or usually their spouses first and then their children. That's usually the way it goes. Very often, the child who's going to be good at the financial part isn't going to be the person who's good at, the medical decisions in a crisis or something. So, you really have to think about who's the best person to do the job, who's going to be able to handle this, who's going to be able to work with other people, who's not going to, alienate people, who's going to, be able to best carry out your wishes in those different arenas. So, absolutely. I can't think of anything else to say about that.
Right.
We want to take questions
So
or.
the financial one does need to be written up by an attorney. The healthcare one, you can use one of these online or 5-Wish, and the 5-Wishes document can be found online. But a lot of people a lot of care providers prefer to see the one drawn up by an attorney.
Go figure.
Yeah.
I mean, yeah. As I said, it's usually, people come in to do their estate planning, and it's just part of the whole package, so, but yes, in Pennsylvania, the law is that basically any form that's validly executed, meaning, it's signed properly and all that it would be honored, assuming it actually addresses the things that need to be addressed.
I think you might not have talked about the HIPAA.
Oh, yes, right. I just sort of
We talked about that last time.
glossed over some things here. So also in the healthcare power of attorney is that what the HIPAA power, which has nothing to do with hippos. HIPAA, Health Insurance Portability Act. What's the other P? Anyway, it's really about patient privacy, and patient privacy laws mean that a hospital or health provider is not going to share your health information with anybody who doesn't have that permission from you to do that. So what I include in my living will, my healthcare power of attorney, is a HIPAA power, meaning that the person who is your agent has your permission, has the authority to talk to healthcare providers about your healthcare. So sometimes trusts are necessary. What is a trust? A trust is where you give property to someone else to hold for the benefit of somebody. That's like the most basic description. So in estate planning, reasons for doing that in estate planning is if you don't want to give something to a beneficiary directly, because maybe there's issues with doing that, whether they're too young, or maybe they have issues with handling money and you just don't want to do that, or you just want to dole it out to them over time. So you can have trust language or a trust within the context of a will, which we call a testamentary trust. Or you can have actually a separate trust document where you have maybe specific property that you want to place in trust, and then you want it managed by a trustee for the benefit of maybe you while you're alive, and then your spouse after you're gone, or whatever. I mean, there's many different situations where a trust might be called for. Most my clients don't need trust. I mean, it's just a will, power of attorney, living will is fine. But if you have, sometimes there are what's called special needs trusts. So if you have an adult child or who is receiving government benefits for their care, and you don't want them to inherit money because it would disqualify them from receiving those benefits, then you might do a special needs trust. We have the question of ancillary probate. One way to deal with the whole ancillary probate issue is to place that property in trust, and then it doesn't go through probate. So, but sometimes that's not even worth it anyway. But so it all depends. So yes, there are circumstances in which a trust might be necessary. Right. So a trust does, in a sense, avoid probate. Now, it doesn't necessarily avoid inheritance tax. So you don't equate probate with inheritance tax, because, probate again deals with property that's titled in your name at the time of death. You have non-probate property also, and trust is a little bit like that because it operates outside of the will. What state does the will operate? Yes, excellent question. Probate occurs in the state of which you die a resident of. So, if you have two homes, Florida and here or whatever, right, then there has to be some determination of what state you are a resident of. If you change residence, you move to another state, while your documents executed in Pennsylvania will be valid in that other state, they may not achieve what you want because their rules of owning property may be different. That's particularly true with real estate, because Florida, for an example, has homestead rules that I know nothing about, but I understand that it's different. I'm not licensed in Florida, and so I don't even pretend to practice law there. But yeah, so if you move to another state, consult and you intend to stay, consult an attorney licensed in that state about whether you need to update your documents. If you have a joint account, either with your spouse or with a child, many people do that. They put their children, like especially if their spouse has died, they'll put a child on their account. If they're a joint owner, what happens at death is that account immediately becomes theirs. So if that is not your intention, then don't do that. Keep it in your name and let it pass through your will and then get distributed as part of your estate. Now, sometimes there might be reasons for doing that, and that's, that falls into the it depends category. But in terms of what happens to the account where there's joint ownership, is it automatically goes to the joint owner. So if there's two owners, like the decedent and the survivor, then half the decedent's share will be taxed at half, tax half of the account. So
and that's one of the cautions that I was told, because let's say you put your child as a joint owner of the account, but then your child gets hit on their bicycle and dies, you then owe the inheritance tax on your own account.
Haven't seen that one yet, but that's a good point.
But the other thing is to be a signatory on the account. A signatory.
Right, so then we get back to the reason for having a power of attorney. So you can accomplish that same objective. Because a lot of times, a sole surviving parent will put an adult child as a joint owner just for convenience sake. Because, well, it's easier. They're a joint owner. They can write checks for me. Well, really, the better answer is to have a power of attorney. That person just has only that power to write checks, but they're not a joint owner of that account. So what's going to be taxed is whatever of that account goes to beneficiaries. So, mom dies and leaves it all to her kids or that one child, then it's going to be taxed to them, the whole account. So, yeah, I mean, if your goal is to minimize inheritance tax, you're not concerned about someone being a joint owner of the account. In other words, if you just have one child and it's all going to go to them anyway, then being a joint owner isn't really an issue unless you have concerns about that person, running off with all your money that you really had intended to pay for your medicines and your food, then yeah, don't do that.
I wanted to add one more thing, going back a couple of topics on the financial power of attorney. That one of the things that my clients have been telling me, and I also ran into, was that the financial institutions want you to use their own document. So even if you've got this lovely thing that you've written up with your attorney, Bank of America says, we want to see our form.
Yeah, I mentioned banks and hospitals tonight. Really. Yeah, we run into that now and then. Sometimes, you need to get your attorney to pick up the phone and say, excuse me, but may I speak to your attorney, please? And you work it out and you get them to accept the duly executed form. Because what happens if the person, they signed the power of attorney and then they became incapacitated and you're trying to use the power of attorney, said, oh, no, we need our form. Well, mom or dad can't execute a new one because that's the whole reason for having it in the first place. Yeah. Alrighty.
Well, let me say thank you very much. I appreciate your coming, and if people have other questions, they can
I'll stick around for a couple minutes.
Thanks very much.
Thank you.
Thank you.